All right, welcome back. We are here with Doug Rohan again to get a couple of updates on the FSU ACC saga that's going down. Recently, the ACC filed a brief in opposition to FSU's motion to dismiss or stay the suit in Carolina. So, Doug, welcome back. How are you doing, man?
It's a pleasure to be here. I'm doing great. Just got back from a beach vacation, rested and relaxed, and excited to see what the month of March holds for this litigation for us.
Yeah, back from vacation, so we're putting you to work. So it works out great. So let's back up a little bit. If you haven't seen everything that we've done, we certainly have a playlist that you can click on top of the screen right now to get caught up, or at the very end of the video, I'll link that as well. But let's back up just a little bit. How did we get here? Where is everything? How many cases are going on right now? Let's start kind of from the top, 30,000 foot overview. Where are we today with everything that's kind of going on?
Yeah, first you did a great job with the intro. This is not easy stuff, and it's why I want to be here to explain it. But just to make sure we have the context for everybody that's listening now, there are two separate cases. One pending in North Carolina that came first because the ACC filed a complaint in North Carolina for declaratory judgment and breach of contract. Then we have a claim in Florida that was filed the following day by FSU, claiming that there was a breach of fiduciary duty and looking for declaratory judgment on the grant of rights and its validity before FSU decides whether or not they want to get out of the conference. Then we had responses filed in each of those cases. So both of them filed amended complaints. First, FSU filed an amended complaint in North Carolina based on what they saw in the filing from the ACC. The ACC filed an amended complaint as well once they got to see what some of FSU's statements were in their filing, in their amended complaint, and in their motion to dismiss. That was the next thing that was filed. So FSU then goes to North Carolina, files a motion to dismiss, asking the North Carolina court to either throw out the case altogether or alternatively to stay or put it on the back burner while we wait to see what happens in Florida. The response then from the ACC was to do the same thing. They have gone to Florida and filed a motion to dismiss or alternatively stay the Florida proceeding, waiting to see what happens in North Carolina. And now yesterday, this latest filing is the ACC's response to Florida State's motion to dismiss in North Carolina. So everything we're talking about today has to do with what the ACC said in response to FSU in the North Carolina suit. And ultimately, that hearing is now scheduled for March 22nd. So that's going to be the big day with the big fireworks to find out what the arguments are presented to the judge. And probably not on March 22nd, but a few days later, what the North Carolina judge's ruling is on this motion to stay, motion to dismiss, or whether or not we're going to proceed with discovery.
So just before we go into all of that, do me a favor, and if you haven't already, folks, I'm going to put the links to Doug's social media in the description. If you appreciate him coming on here and chatting with us and explaining this, I know a lot of you really do like this video. Listen, you guys can comment questions. We've tried to answer some of those. You can do all those things that we appreciate. But if you appreciate what we're doing here with Doug, go follow him on social media. It's Rohan Law PC on Twitter or X, wherever you use. That's where I would suggest the most. If you're a Facebook user or Instagram user, you can go follow there as well. But you're going to get more of the FSU content that we're maybe talking about here today on Twitter. So go check that out. It's Rohan Law PC on Twitter. One more question, though, before we go, Doug. Will FSU answer, and I don't believe they have, FSU will answer and basically do what we're talking about today. They'll do that in Florida too, right? The ACC asked Florida to kick this out or stay it. Florida State will answer that as well.
Yeah, these are mirror cases. These are mirror motions. What you see in one move is going to be the equal and opposite counter move on the other side. It really is fascinating. What was one of my tweets yesterday? I wish, somebody asked, is the same litigation team or the same attorneys handling both lawsuits? And no, that's not the case. In Florida, you have to be licensed as a Florida attorney. So both parties have Florida attorneys. In North Carolina, you have to be licensed in North Carolina to practice law. So both parties have North Carolina attorneys representing them. Obviously, there is some communication. I'm certain that there are some discussions and strategy sessions. You have two sets of highly qualified attorneys. They should be sharing knowledge. But in both cases, they're basically arguing the opposite point. It's like your old debate club in high school, or a lot of times these mock trial competitions. I really wish that the same attorneys would get to argue the exact same cases on both states, because they're saying the opposite thing. Whatever the ACC is filing here, what they're saying is that this has to be heard in North Carolina because there's been a breach. A week ago, they said the opposite. They were just in Florida saying this shouldn't be heard in Florida because there hasn't been a breach yet. So it really is comical. But yes, to touch on that point, there are separate attorneys handling both cases. They're both matching each other's moves in the opposite case. And frankly, they're both arguing oftentimes inconsistent points in both cases.
Because you just need to win somewhere, right? Like and so what you're arguing in one, like like you said, you tweeted and yesterday, like filing that the breach hadn't happened here, so throw this one out, and the breach has happened here, so keep it in, is hilarious. But it's not. I assume you can't really go and use the. Can you say like, hey, they filed in Florida saying like they're contradicting each other? Is that even admissible in the other court?
No, and it's known. It does happen. It's not relevant. It's not valid in terms of arguments, but this should give you some indication and some understanding why I, as an attorney, even though I'm a Homer attorney that's been accused of being an FSU shill in this case, the reality is that we don't know what's going to happen because different judges think differently about certain arguments. And just because it's being presented on one side or the other side, both parties have some good arguments in their favor. Both parties are really throwing some duds out there, and sometimes the duds end up landing inexplicably in the right place, and sometimes the winning arguments might be the best arguments out there, but they're still not bought. That's why litigation is so complicated, so unforgiving. It's the closest thing we have in the business world to what happens in sports. You have two opposite teams fighting each other. It's very few people out there that are watching these videos that have an employment situation where there truly is somebody on the other side trying to prevent you from doing your job. But that's exactly what happens here in litigation. So you have two parties throwing out all kinds of arguments, some good, some bad. There can be a difference of opinions as to which ones are good and which ones are bad. But ultimately, the judge is going to pick and choose which case decisions that he wants to follow, which case holdings from before that he thinks are most applicable, and he's going to decide, or she's going to decide, what is the best outcome for that case in that jurisdiction. And that's why we don't know what's going to happen.
So, looking at the news that came out yesterday, we have the ACC basically saying that FSU is wrong and the North Carolina case should not be dismissed and shouldn't be stayed or held up or placed on the back burner. Obviously, the ACC wants this to move forward in North Carolina. That's the high level watermark of what the ACC wants here, and just kind of stay here. So let's talk about the points of why the ACC says or thinks or is posturing for Florida State to be wrong, based on what you sent me. Explain to me what this means, but there was and is a justiciable controversy claimed by the ACC.
So, in both motions to dismiss, the first thing that both parties say is, look, there's not even a case here that's worth discussing. Now, obviously, there is, because there are going to be millions of people tuned in to find out what's going on in this case. But both parties are trying to come up with some technical reason why the case isn't ripe and isn't ready. So, Florida State's argument was the ACC rushed out before the Board of Trustees meeting and filed this lawsuit accusing us of breaching the grant of rights and accusing us of breaching our fiduciary responsibilities to the ACC. Well, that happened before the Board of Trustees meeting. But what the ACC is saying in their response here is, no, even though the Board of Trustees meeting took place the day after, that was first a technicality. They already had drafted the complaint. They had already met with each of the board members individually. The decision had already been made. They just hadn't taken a vote yet. Two, the reality is that they've discussed breaching this grant of rights and breaching their obligations to the ACC since the August 2023 meeting when they first started lobbing bombs. So that's why they're saying that there really is a validity in the ACC filing the complaint first in North Carolina.
I mean, to me, and I'm a homer too, right? I'm wearing an FSU shirt, hat, everything else, right? Like everything's garnet gold. But like to me, I don't necessarily think that they're super wrong. Like obviously, I can't speculate on how a judge would rule on that. But for Florida State to say, I thought the ACC got a pretty good zinger in, and we'll talk about that one in a moment. But just as a common person, as a lay person that doesn't understand law, I mean, I don't necessarily disagree with the ACC on that. What are your thoughts there?
I am of the same opinion as you. Well, one of the things that the ACC keeps harping on is that a version of this brief or something was leaked the morning of the Board of Trustees meeting before the Board of Trustees meeting happened. And the mere existence of the complaint is proof that this was going to happen. Well, yes and no. The reality is that until something is voted on and then until something is filed, it doesn't exist. I have lots of drafts of different motions and briefs that never end up getting filed. Just because they exist doesn't mean that it is actually something in controversy. So yes, the ACC has some arguments. Look, this was inevitable. And yes, FSU has some arguments that the ACC was premature. But again, I go back to what I said earlier. They're both arguing the opposite in Florida. ACC is saying that nothing has actually been breached, so there's nothing for the Florida court to discuss. So this is just one of those examples of people put stuff on paper and they make arguments. But you're right. Neither party has a very strong claim to this particular issue.
So the next one, FSU's motion does not show that the ACC's complaint was unauthorized.
Mm-hmm. So this is one of my favorites because it is what I wanted to come in and dig into. And in some of our Twitter conversations last night, I wanted to put this on the back burner yesterday because I needed to come in, read the bylaws again, look through everything. So technically, the way the bylaws are written is that 2/3 of the members are required to vote on any material litigation. Material litigation is not defined. I think we can all agree that kicking out a member or accusing them of breaching their agreement is material litigation. So let's just for now presume this is material litigation. Well, FSU said when the ACC filed their complaint in North Carolina, they had not gotten the votes of the members. So in this case, the ACC is responding to that allegation saying, okay, fine, you're right. We didn't get that vote done before the original filing of the litigation. However, we met in January. Okay, well, FSU wasn't told about a meeting, and 2/3 of our members did authorize starting this suit. So I wanted to go back and dig into that, see what was possible. There is nothing in the bylaws that mandates or requires notice to all members, but it does say they do require 5 or 3 business days. I forget which. Florida State has a 24-hour notice. ACC is either 3 or 5 business days. So there is a required notice ahead of time. There is a required agenda to be published about what that meeting is entailed. The commissioner alone has the right, if he wants to call that meeting. 2/3 of the members must be present, so they don't require complete attendance, full attendance, but quorum and the votes needed to pass are the same, 2/3 of the members. So that means that allegedly, based on the affidavits, 2/3 of the members of the ACC have, at some point in January, voted to authorize this litigation. Now, there are really 2 problems with that. First, is there some substantial notice or some notice required of FSU? No, I don't think there is. If you're going to kick somebody out, you're not going to give them necessarily the heads up that you're about to kick them out. So I can see how the ACC can get away with that part of it. What I don't agree with is this idea that they can retroactively validate their original filing. So in this particular case, they're citing to a 1982 decision saying, oh, well, in that private entity, there was some board discussions later that authorized the prior action. Well, this isn't a private entity. This is a conference consisted of members from across the country, from multiple states. And again, you did not do this prior to initiating the litigation. So if that's the strongest argument they have, a 1982 case involving a private company that they're trying to analogize or they're trying to make related to this situation, I think the ACC probably has a significant problem here.
Yeah, to me, this seems like the biggest issue. So, I guess the more drama filled side of it is they kind of went. I mean, again, not required to reach out to FSU for everything, but I mean, I assume they just went to what, like Wake and Duke and Syracuse and BC and teams they knew would vote with them. I bet they didn't go to Clemson, right? And said like, hey, we need to take a vote on this. And so they went to those. I mean, 2/3 would be 10 teams, right? And
Mm-hmm.
so, or 10 universities, and got the vote that way, just kind of like under cloak, like under nightfall or whatever, and made sure that FSU wasn't aware of it. Is basically what they're alleging. And I assume that Clemson and UNC probably weren't part of the vote either, but that's just my speculation on it.
Yep, that's what I would probably agree with as well.
Um, Next up, North Carolina has jurisdiction over Florida State was another argument that they levied.
So we've said from the beginning that jurisdiction and venue are the two similar items that are going to be very important. Jurisdiction is, can FSU be sued in North Carolina, and venue is, is it appropriate to be in the courthouse in North Carolina? The argument here from the ACC, I think, is again one of their weak arguments. Again, this is the opportunity to put on paper your strongest arguments. What North Carolina cited to is a case involving Troy University in Alabama that registered as a business entity in North Carolina. And they're using that as their hook to say, see, other universities can get sued in North Carolina. The problem is Florida State hasn't registered any business entity with the Secretary of State in the state of North Carolina. And this is a very formal and particular issue. When I registered my law firm, I had to name all the corporate officers. I had to name who the registered agent is. And the registered agent is important because they're authorized to accept service of any lawsuits against me in this state. Well, of course, if Troy University registers in North Carolina and they outline who their parties are and representatives are, including who is going to receive lawsuit service of process, then they are clearly availing themselves of the North Carolina jurisdiction in the case of any lawsuit. The ACC tries to say, well, FSU joined the ACC and that's the same thing. No, it's not the same thing. When you joined the conference, you did not register with the Secretary of State and file a notice, this is my registered agent for any lawsuits in North Carolina. So again, they had an opportunity to come up with all their legal reasonings as to why this should be a North Carolina jurisdiction, why FSU should be subject to the jurisdiction. And if that's their strongest argument, I don't think it's a particularly good one.
This was an interesting one when Florida State brought it up, and a lot of people, it almost not as strong as a gotcha moment, although that's subjective, right? And people can say what they want on it. But the idea that the grant of rights was invalid due to Florida State not truly executing it because their board of trustees is not the one that did it. It was just signed by the president.
Mm-hmm.
Basically, the ACC saying that doesn't warrant a dismissal. That Florida State says, yeah, we didn't technically even sign this thing, or the right people didn't sign it, and the ACC says, no, we're not buying that one.
So remember, the level, the standard for a dismissal is the judge has to say, okay, everything that the other party has said is true, everything that the other party has said is accurate and correct, and there still isn't anything worth discussing here. So what the ACC is saying is, we don't think that the argument that the president didn't sign this agreement is strong enough to say the agreement doesn't exist. Now, I did some additional research on this last night. There was a little bit of a Twitter kerfuffle, we'll call it, going through there. And there is something that was discussed that is a potential issue here for Florida State. And again, I like law, I like litigation because at the end of the day, it's usually pretty fair. And so when we discussed previously that the president didn't sign and therefore the contract is invalid, that is probably an overstatement of the reality of the situation. There is a scenario where the board of trustees, who is the authorized party to sign contracts under Florida statute, can still be put in a position where the grant of rights or the contract with the ACC is valid because the president signed. And the basis for that is this idea of agency estoppel. If somebody, in this case the president of the university, signs an agreement purporting to say, I have the authority to sign this agreement, and nobody challenges that authority, nobody steps in and says that the president doesn't have that authority, then in effect, they are creating the authority necessary to make that contract valid. So the argument on the ACC's part should have been, and this is what's important, they didn't specifically state this in their motion, but what the argument should be from the ACC is nobody on the board of trustees in the 37 meetings that have happened since this contract was signed came forward and said the president didn't have the authority to sign. So because they didn't say that at any point in history, they shouldn't be able to say that now. That is a question of fact and law that a judge should decide. So again, the ACC is saying this is enough of a reason for us to continue the litigation. This is not ripe for dismissal. But once again, they didn't actually allege the three factors necessary to create agency estoppel in their complaint or in their response. So is there really a strong enough argument on the part of the ACC? All we've decided based on this portion and what the judge is likely to decide is let's keep going. Let's dig deeper.
It's like giving your wife your credit card and then 10 years later saying that wasn't me that used the car.
Correct. That's a great example.
Well, why didn't you say something 10 years ago? Which I get, right, from the ACC side. But like you said, you try, and if you're Florida State, you're the ACC, you're certainly trying to throw as much at the wall as you can to see kind of what stays up there and what you might win on. So next up, filing first, again, is the big issue here. Were there any new developments in this argument, the race to the courthouse comment?
Yeah. So this touches again on our first factor that we briefly got into. This is going to be a major part of the hearing on March 22nd was North Carolina's filing reasonable? Was it accurate, or was it simply a strategic move to try to undercut Florida State's lawsuit in Florida? Now, one of the good lines here that the ACC put in their brief, I like the line. I disagree with the overall message, but they said that in this case, FSU's grievance is not that there was a race to the courthouse. It's just that they lost the race to the courthouse. Okay, that's cute. I love when attorneys get a little petty in their filings. That's kind of what spices up these discussions and this litigation. But at the end of the day, the ACC is admitting essentially what Florida State is accusing them of. Yeah, there was a race to the courthouse. Okay, well, the race to the courthouse is one of the factors that authorizes a judge to say, let me take a step back and really examine whether or not it's appropriate that there was a race to the courthouse. So in the effort by the ACC to try to get a dig in at FSU, I personally think that they have harmed their argument about this being reasonably held to be first in North Carolina.
No. The phrase on social media a couple of years ago used to be your own tweets. It might end up being their own dig that hopefully gets them in this one. Okay, we want to talk about like where this leaves us now. You mentioned the hearing on March 22nd. Before we go on super far there, I know you said they won't really consider stuff from the other. Like, is the judge in North Carolina or the judge in Florida like somewhat considering anything about the other case? Like, would they ever have a discussion and say like, hey, let's just both agree to kick this up to federal court? Like how, like, I would assume both cases wouldn't just continue to run congruent. Like how will that, at that point, if both judges are like, yeah, both people have a case, like how would that come about?
So let me step back and give a broader answer on kind of what I think the timeline is going forward.
Sure.
We know March 22nd is a hearing in North Carolina That hearing is related to all of the filings in North Carolina. A scrupulous judge is going to focus strictly and solely on the filings in North Carolina. Now, every judge has a law clerk. Every judge has their own legal team that's going to go back and make sure these are real cases, not AI generated cases for precedent. They're going to make sure that all of the issues have been accurately reflected in the briefs, and they can do their own legal research, but that research is going to be limited to the North Carolina case law and North Carolina cases that are similar. A good North Carolina judge is not going to look at the Florida case or consider anything from the Florida case. They're obviously aware there is a Florida case, but other than that, I would not expect a reasonable judge to do anything other than be aware that a lawsuit exists. Similarly, in Florida, they're going to be focused on Florida law and the Florida briefs. And so, yes, they do stand in some ways separate. In legal terms, we sometimes call this a Chinese wall that happens in law firms where attorneys are conflicted out of cases. So you just say, I promise that associate is not going to look at anything to do with this file. And there are some serious repercussions if you break that Chinese wall. So as a result, most ethical and responsible barristers, judges will stick to their ethical canons and will make sure that they're just evaluating the information before them on their case. I would expect probably in the next few days or weeks that the FSU files a brief similarly in Florida. I would expect the Florida judge at some point to set a hearing date for the Florida case and the Florida motions to dismiss. Whether or not that happens before or after March, that's going to depend on the calendar of the judge. Since nothing was filed last week for a court date March 17th or March 22nd or earlier, then I suspect that that judge is going to go after the North Carolina March 22nd hearing. As far as whether or not both cases could proceed, sure, both judges could say, no, we want it here. And if that happens, truthfully, I don't know exactly what the procedure is. I believe what we've talked about before, what I've heard from some other attorneys, is that you can then have either party remove the case to federal court. North Carolina goes to North Carolina federal court, Florida court goes to North Florida federal court, and their federal court judges can then sort out which case should take priority if there's any relevant factors that they think the lower court didn't accept. There can be moved to a court of appeals. Both the losing party on each side can ask for a certificate of immediate review saying you have entered a decision that's going to affect the rest of this litigation. Before we proceed with the rest of this litigation, we need a court of appeals in North Carolina or a court of appeals in Florida to look at this issue. That's another possibility. And that's why I say the waters are getting very deep. I promise I will learn as we go, and I will pick up the information that I can from others, and we'll sort it out and explain it to you all. But that's kind of where the next few days and weeks look like. And of course, in the meantime, the ACC could go ahead and wrap this up. FSU could wrap this up. We've got our private equity conversations that have taken place and some additional bonds and funding. So we could get nowhere. I do think that March 22nd goes forward. I am going to try to be at that hearing, and we'll see what happens on that date. But I think that both parties kind of want to see how this first test case plays out before they get serious about what the numbers are going to look like.
We'll wrap up with this. We had a question from Tattoo Harry about depositions and scope. You want to go into that a little bit?
Yeah, he had asked me after our last video about, now that this case is moving forward, what exactly is the scope of discovery? And I know that you had a question, early on also. Some others had questions about, are we going to get into Free Shoes University? Is something from 1992 going to come up? What about, the crab legs and things like that? The discovery is going to be limited to specifically issues that are related to this case. It is a broad scope of discovery. The test is generally, is this admissible, or is it likely to lead to the discovery of other admissible information? So that is what shapes the discovery process and gives both parties a wide latitude to get into documents, depositions. So specifically, Tattoo Harry was asking about, can John Swafford be deposed? Can Chad Swafford be deposed? Can ESPN officials be deposed? Absolutely, because all that is going to go into FSU's argument of a breach of fiduciary duty. So if the judge agrees that these are the parameters of the case, these are the issues of the case, so that has to happen first, But those depositions could absolutely start in April or May, depending on the scheduling orders from the judges and what happens for both of these motions to dismiss.
Awesome. Well, Doug, I appreciate you as always for jumping on and chatting with us a little bit. Like we normally like to do, tell us a little bit about Rohan Law, and then we'll do our best to get out of here.
Yeah, Rohan Law is based out of Atlanta. We handle criminal defense, personal injury, and workers' compensation, any work accident. So I really hope you don't need my services. If you do, and if you're calling me, it's a bad day. But we do want to be your best friends on your worst day. So if you or a family member find yourself in Georgia with some legal problems and you're looking for someone that you want to come alongside you, please give us a call and let us know how we can help you. Our services, typically the consultation is free. Obviously, you have to pay us a retainer for the criminal defense matters, but on the civil stuff, we take a percentage from the insurance company. So you don't have to worry about whether or not you've been injured at work and also still have money to hire an attorney. We'll take care of that after we beat up the insurance company and make sure that we get your benefits. So if you're in Atlanta, reach out to me, say hi, follow us at the Atlanta Seminole Club events, or say hi the next time we're in Tallahassee for any of the FSU games that we go to frequently.
Or Dublin, coming soon.
Dublin, we've got our hotel, we've got our tickets, we've got our plane. We are set and ready to go. We just got all those plans finalized last week.
Awesome. Good stuff. Well, Doug, I appreciate it again. I'm sure we'll have you back soon, probably before the 22nd, but if not, on or around the 22nd, man. Thank you so much for your time.
Thank you, TJ. Take care.